and share my computer again. Okay, please let me know if you see my screen where it says procuring cost disputes. Yes?
Yes.
Okay, awesome. Thank you very much. All right, so what is procuring cost dispute? Basically, it's a dispute between two or more agents involving a buyer, and sometimes it can even mean involving a seller as well. But the majority of times when we talk about procuring costs, and if you've never heard that phrase, it's basically a buyer that goes in a different direction, but you feel that you're entitled to some type of commission because you are the party that ultimately procured this event, this transaction. And the buyer ends up going in a different direction. So usually the party that is damaged will file a procuring costs dispute. All right, so let's go ahead and dive in. And as I mentioned in the past, most of the information that I get is straight out of the California Association of Realtors. All right, so before we get started into the meats and potatoes of what a dispute really entails, and then what the scale weight, and ultimately who is the decision maker on who is entitled to a commission, we got to go through so many phases and parameters to get to a procuring cost dispute. Starts with the multiple listing service and the offer of compensation, okay? Because that's where the core of information is, because you got to lead to an argument and why you're entitled to a commission. It's a very simple process if you understand every element of your position. Now, I'm not an attorney, and most of the information I'm going to provide you is an avenue to how to navigate and ultimately make it a win for you and your potential client, or at least get paid a commission. So a offer of compensation is generally made in the multiple listing service and is governed by its rules. All right, how many people have navigated on the MLS? And ultimately saw on the MLS on the very bottom, because that's the first thing most real estate agents go is, you know, the MLS. Are you here for the class?
Yeah.
Oh, okay. Hold on, team. Let me transition. Do you have your computer by any chance? Okay. I'm gonna place. No. Let me just go ahead and put it on the computer real quick. Hey, team. I apologize. Let me place you on a quick pause. I'm going to transition and put it on the flat screen TV. So I apologize, but let me square away with the flat screen. All right, team, we'll get started in a few minutes. I do apologize. Okay, is she showing up? It's not coming up yet. Scheduled for 12/7. Everyone hear me okay? I'm not sure why it's not coming up. Pardon me 1 second here. Oh, that's
for the meeting schedule for 12/7.
yeah, that's why.
Yeah.
Let's go back. Right here. Here we are.
There. There.
Okay. Ah, here she is. All right, I see you now. Okay. Sorry, team. All right. Everyone gets a gift card from me for being patient. All right, team, as I was saying, so we're good now. The MLS and the offer of compensation. The California Model Rule 7.2 of the MLS Rules and Regulations says in filing a property with the multiple listing service, the broker participating makes a blanket unusual contractual offer of compensation to the other MLS broker participants. So anytime you put it into the MLS, what you're saying to the multiple listing service is, we are paying a compensation to a cooperating brokerage. And when you scroll down on the multiple listing service, you'll see on the bottom where it says compensation, you'll see a flat fee or a percentage. Typically, you'll see the percentage, right? 2.5% or 3%. Or maybe you'll be one of the lucky agents that sees it as a bonus and they're offering, more than 3%. I've seen 5% as a bonus if you can close at a certain time frame. So in respect, that's where the information, and that's where, again, we have to kind of navigate and who is responsible for paying on a procuring costs claim. California Model Rule number 7.3, the offer of compensation is accepted by the cooperating broker by procuring a buyer, which ultimately results in a creation of a sales of a lease or a purchase of a contract. Absolutely. So in order for this to be valid, you must have a buyer and a seller, you must have a listing agent and a buyer's agent, and there must be a contract in place. And that contract is drafted by the agent, right? Signed by the buyer and submitted to the listing agent, which then in return, the listing agent will provide that information to the seller. If the seller is in agreement to the terms of the purchase agreement, then the seller will sign off on the purchase agreement, agreeing to the terms of the offer. If there is no agreement to the purchase agreement, then the listing agent and the seller will provide you what's called a counteroffer or a multiple counteroffer, basically stating the fact that, yes, look, we see the terms that you provided, but we're modifying some of the terms. And that's where we go back and forth and until we ultimately have a clear, concise agreement, and that becomes a modified agreement in place. And that's when you start the escrow period. So the compensation starts with the MLS under the Rule 7.2, 7.12 and 7.13. Now let's dive into what a procuring cost is. Well, the National Association of Realtors defines it as an uninterrupted series of causes events which results in a successful transaction. So that's what NAR definition is. Basically a smooth transaction, meaning there's no hiccups, no interruption, no one is interfering with the process of getting the buyer's offer accepted, the buyer's due diligence period, the negotiations, and ultimately the closing, okay? So the opinion of the National Association of Realtors is, well, that agent, and that can be myself, Christine, or anyone on this call, as the procuring agent in the successful closing of the transactions. A factor test that does not necessarily have one trigger event that will give a sure result. So there's many ultimately factors in place, right? One, you have to have a buyer. You have to have a qualified buyer. The buyer must be ready to submit the offer, execute the purchase agreement, right? And then ultimately accept either the terms of the seller, open escrow, and go through the whole motions of getting pre-qualified, going through the motions of inspections. That's a multiple of factors that results to what we call a procuring cost. Okay. And then disputes occur with more than one agent asserts they're entitled to the buyer's side commission. And we'll dive a little bit deeper into the conversation, and I'll give you an actual real life war story that actually happened to one of our agents here at the office on a procuring cost claim, and what the outcome was when we ended up going into a arbitration case. And there's many elements that lead to an arbitration. Now, the contract is very clear and concise, and it's very black and white. It tells you the answers to all your questions. The problem that I see with a lot of real estate agents, they don't read the contract. And when I say, have you read paragraph 4, paragraph 5, paragraph 22, they don't know the answer to that question, okay? This is why it's very, very important, team, that you understand the elements of every component to the RPA, the purchase agreement, because your answers are there. If you don't know what's going on, revert back to the purchase agreement and the answer will always be there. Escrow follows the escrow follows the purchase agreement. Title follows the purchase agreement. Agents should follow the purchase agreement. And guess what? A lot of real estate agents, unfortunately, don't. They try to take shortcuts, or they just do not understand the initial process. But again, go back to the contract and the answer will be there, okay? Now, on a procuring cost claim, team, there has to be what's called a burden of proof, okay? What does that mean? What does that entail? Well, the broker who files what's called an arbitration, and I'll explain the different elements as well, because on the purchase agreement, it defines two components. It defines mediation, and it also defines arbitration. And once the buyer and the seller agree to the terms of the RPA, and more so the agreements of the mediation arbitration, then we must follow the direction of what the purchase agreement entails. You must try to mediate or escalate it, and must try to arbitrate before you escalate it into a potential lawsuit. That's what the contract stipulates. It's easier, it's more cost effective, and you don't really necessarily have to get an attorney involved because it's a dispute, it's a disagreement. And there's always going to be disagreements between a buyer and the seller. Well, buyer is not completely happy with the overall condition. This is the reason he submitted a request of repairs. Seller comes back and says, look, Mr. and Mrs. Buyer, unfortunately, the property is being sold in its as-is condition. Therefore, we're not going to do any request of repairs, no credit, or a price reduction. Or the buyer can come back and say, well, let's send out a second request of repairs, or back out of the deal, or just bite the bullet and buy the property. So negotiations are being done throughout the initial process, beginning when you submit the offer, during your escrow period, and then sometimes at the very end, you might have to negotiate or an extension of time because something is still not aligning and we're not closing on a timely manner. This is where your expertise and your professionalism comes into play, team. This is where you need to step up and understand the rules and regulations, and ultimately the responsibility of what the contract says. I will consistently be telling you throughout the session, follow the contract, follow the contract. Now there's two components to the purchase agreement. That's what we call the black and white, and what we call the spirit of the contract. The black and white defines exactly what the contract says. 17 days for appraisal to be removed, 21 days for loan to be removed, 17 days for physical inspections to be removed, 5 days for the seller to provide disclosures, right? So the contract defines the black and white. Now, the spirit of the contract is what we call a bend in the contract, not a break, but a bend in the contract, meaning that regardless of what the contract stipulates and says, there's always going to be some type of bend where it goes to the left, where it goes to the right. It will never always go directly as smooth as you thought it would. That's where the bend will come into play. And this is where your, again, expertise, knowledge, and experience will come into play to understand both sides of the court. If you're representing the seller or if you're representing the buyer, one or the other, you're still in the game to ultimately finish and get to the end goal, which is closing the transaction, because that's when you will get paid a commission. Okay. Generally, the broker filing the complaint is the one who does not have the commission. And that's typically if I feel that I was entitled to a commission because I was the procuring cause of this buyer buying this property, but I'm not getting any type of commission because the buyer ended up going in a different direction, I have the burden of proof to provide the evidence of why I should be entitled to that commission. So that's what today's lecture is, understanding your role. Now, I hate to say this, ladies and gentlemen, on this call, is that this industry is a very cutthroat industry, okay? It's a career that you either survive and hunt every single day, because there's no promise, no guarantee that the buyer will do business with you. And I have a phrase, and you probably heard this many, many, many times. Buyers are liars, okay? Buyers are liars. And the reason I say that is because it's no different than a marriage. It's very exciting in the very beginning when you do have a buyer, and now you're doing what we call a buyer representation agreement, which is similar to a, what's the word in marriage? A prenup? It's a prenup, basically rules and regulations. These are the rules. I'm a true believer, now that I got my butt kicked from my ex-wife, that, a prenup is very, very important, very necessary. And it's really just instructions, no difference than a trust. Something happens to me, I have instructions that are in place that if anything, God forbid, happens to me, that I have instructions after my death that these are what I request. So a prenup is the same thing. It just sets standards of what this will be if we decide in the future to separate, to divorce, and go our own way. Okay. I always get chuckles when we have in-person lectures on this, but again, I'm just being very transparent and very open, because you're going to deal with sometimes situations similar to this, divorcees. They're trying to sell their property, a buyer that they're all happy, and then all of a sudden they're now fighting and argument, and then now they're going in a different direction where they're not going to buy. And I've seen every case, every scenario. So just go in for the ride and hope for the best, and again, really your professionalism will play a big factor to glue that transaction, stick that transaction, and continue to close. And again, please feel free to chime in if you have any questions, or if anything doesn't resonate or you don't understand, just please let me know.
I have a question.
Yes.
So in this situation, like you say, it's very necessary before even listing the property, if there are any kids and kids from the step, whatever. Right. Then how can you get the information on this regard, like beforehand, so that you are already in the way that you're safe play? Yeah. The question that came in, and this is representing a seller, right? Yes. And more so a seller that's in a trust. How do we distinguish who is the responsible party that has the authority on a trust to actually sign off on behalf of the trust and navigate the closing? Well, as professionals that you are, this is your responsibility to ask a lot of questions. And some of the questions is, do you have a copy of that trust? That's the first thing that I would be asking is, can I get a copy of the trust? And on that trust, I'm going to see
if the person that's in front of me has the authority to sell the property, because I don't want to spend my time, effort, and energy on a seller that cannot and does not have the authority to sell the property, because you're going to be wasting time, money, money in marketing and time. So the goal is to nip it in immediately and ask the right questions. So to answer your question is ask the right questions. As you know, do you have a copy of the trust? And identify if that person is, because remember, at the end of the day, title will not be able to transfer ownership. So do your due diligence and be proactive about it. That way you're not going, into a transaction, into escrow, and realize, oh gosh, you know what, 10 days into escrow, you're not able to close because the authorized party is not the person that you originally had the listing signed. So be proactive, look, read, proofread, and then maybe have your office look at it, your broker as well, to look into it. So that way you may know that there might be two people that are supposed to sign off on a listing agreement in order for you to sell the property. So these are things that sometimes agents definitely miss. And this is why you want to anchor that and maybe have a second eyes to look over the trust, because it can be as thick as 100, 200 pages long, depending on how long that trust was done. Let's say it was done 20, 30 years ago. And throughout the years, they've modified it, added new stuff, new family members. So what started as a small stack of papers can now be a big stack. So there's a lot of information that you have to go through, and more so. Escrow is going to want a copy of that, and title is also going to want a copy of that, and more so the death certificate as well. The death certificate will be another avenue that they want to make sure that proof that if you are the designated successor to that trust, that you have the death certificates, because again, they want to know, okay, do you have the authority, or is the party still alive? And if the party is still alive, then is there anything else that states on there if you're incapable to sign off on the agreements for medical reasons or whatever that case may be. So again, as a professional, make sure you have a copy of that trust. And then also, if it is the person on title, was it one person or two persons or multiple persons, and they're all deceased, you want to make sure that you align yourself and ask the right questions. A copy of the trust, a copy of all the death certificates. And if they don't have the death certificates, then it's a very simple process. They can go to the county recorders and request copies of their death certificates. So that's ultimately the way you navigate to make sure that you are not wasting time on this. I hope that answers your question.
Thank you.
All right. Procuring cost factors. A complication of facts that are considered by an arbitration panel to determine which broker is entitled to a commission. That's absolutely correct, team. So one of the series of understanding the mediation and the arbitration part of the RPA says the fact that on a mediation, it's a very simple process. It's one person mediating both parties. I can be a mediator and I can have the buyer's agent and the buyers in one room, and then I can have the seller and the listing agent in another room. And my job and my goal is to ultimately come to a final conclusion that we can meet in terms and agreements to the agreement, whatever that is. So my goal is to go and talk to the buyer and lay the facts, and then bring those facts to the argument table with the seller and bring the argument facts from the buyer and see if we can compromise or ultimately come to some type of resolution. That's typically a mediation. An arbitration is totally different. It takes a little bit more time, a little bit more money, but ultimately it's no difference than what you would see in a court hearing. You have either a retired judge or retired arbitrator or mediator, or someone as a retired attorney listening to the case. And it's no difference than going into the court, but without going to court. Usually these arbitrations are done at some type of association, such as, your board, wherever you're a member of the board, if it's the Los Angeles, the South Bay, the Long Beach, wherever you're a board, they usually have a section where they do arbitrations. And it's setting the time, setting the paperwork, and arguing your position on why you're entitled to the procuring costs, why you're entitled to a commission, because that's what leads to why you have these complaints coming in. Once the arbitrator finalizes, receives the documentation, they'll analyze and see the findings in the report. You have to provide them with a summary, basically your case on why you are entitled to procuring costs. Once that is done, then they'll reach out to the opposing party and ask for them as well to provide a summary. They'll compare both summaries and determine, okay, is this something that we have to escalate now, or is this something that we can do via email or via Zoom? If the case is more complex, then usually you'll end up going in person and arguing your facts. Now, it's no different than going to a court hearing. You as the agent or you as the buyer will have the burden of proof of why you're entitled to a procuring cost or a commission. So it's a beginning, opening argument, and then it's what we call cross-examining, okay? Meaning that you now can talk to the opposing party to ask questions, to really open up the reason why you're entitled, basically to catch them in a lie. No difference in what an attorney will do when they put someone on the stand to ask questions, to hold them accountable, or find any truth or no truth or lying in front of the arbitrator. Okay. Once the cross examination is done, then it's what we call your final statement. After all the elements of your opening argument, your cross examination, and then your final statement on why you're entitled to a commission, that is given, and that's given to all parties to do their final. And then within 20 to 40 hours, depending on how many cases they have, you'll get a response either via email or a letter on who the winning party is. So that kind of goes through the chain of how an arbitration does happen. So the compelling is a chart and based on factors gathered from many sources that have been used by many arbitrators. So the cool thing is that the California Association of Realtors has a booklet that you can download a PDF, and actually gives you step-by-steps on instructions, and even gives you case studies, but also gives you samples of how to prepare for an arbitration. Remember, you're like an attorney. You're going in there representing yourself. Usually your broker, your manager should be with you as a support, because they're also involved with this, because they're also going to be entitled to some type of compensation if you're the winning party, okay? So the chart is not to be used as a numerical system to give points to one side or the other. It's just given a circumstance, some factors will not be present, others should be given more as a weight. It is a guide to raise and consider relevant use, okay? If you like me to provide you with that booklet, it's a PDF, shoot me an email, and I'll be more than happy to send you over the procuring costs instructions. I think it's about 150 pages long. I can email it to you on a PDF, and if you need it as a resource, then it's great reference, and it's just a great avenue to really just understand the dynamics of how an arbitration happens. All right, so the categories of the factors, okay? Connections to the transaction, the relationship of the both brokers to the buyer in a particular transaction. So this is where we start really going into the meats and potatoes and who is the compelling brokerage, okay? When they say brokers, they're actually saying companies, okay? A Keller Williams with a Remax, a Keller Williams with a Century 21, a Keller Williams with any other brokerages, okay? That's when they say and refer to brokers, they're referring to your office, your Keller Williams office. So the connection to that transaction is, okay, what proof does your client have, your agent have? Do you have a buyer's representation agreement? Okay, that's the first thing. That is one of the layers to protect yourself is the BRE form. Okay, are you having a consulting meeting with the buyers? Or you just happen to do an open house, right? And a buyer comes in, the buyer falls in love, puts it on the registry that they're not working with an agent, are interested in buying the property, and ultimately you get an offer and you realize that the buyer that's on the purchase agreement was the same buyer that came in and saw the property that you hosted as an open house. Okay, is that a compelling position of procuring costs? It depends. It really, really depends. Because again, we can argue the fact that, yeah, I induced the opportunity because if it wasn't for the open house, the buyer would have never gone into the property, wouldn't have seen the property, let's just say, and wouldn't have submitted an offer. Now, the question is, who is entitled to a commission? Is it broker A or me who introduced and opened, answered all their questions, right? Introduced them and, had a conversation, and on the registry, right, when they signed in, they indicated that they were not working with an agent. And then we realized that they were working with another agent. They were just misleading, and they were able to get as much information on the property because you thought that, you were going to have a relationship and be working with this buyer. So you got to be very, very cautious about that and understand asking the right questions, even as a agent doing an open house team. All right, ask the questions and don't be shy. Mr. and Mrs. Buyer, thank you so much for coming to the open house. Out of curiosity, are you working with an agent? Have you been pre-qualified? Okay, if the answer is yes, who's that agent? You can ask these questions because sometimes the buyers are not telling you the truth. Maybe they don't want to let you know. Or maybe they're misleading. They just want to get as much intel so that way they can arm and position themselves in hopes that they can get as much information to position themselves when they submit an offer. And then you think, oh my God, I exposed everything to these buyers. And now the buyers that I did all this time, effort, and energy went with another agent. So that's one of the pillars of what a procuring costs. And we'll talk a little bit more on how to protect yourself and ultimately navigate to really make it a win for you and ultimately get a commission. Buyer's choice. Why the buyer left the original broker, and if there's a reason, was so justified as to defeat the original broker procuring cost claim. Remember, because you can be on both sides of this position, meaning you are hosting an open house as an example, right? And you do such a phenomenal open house that you connect with someone at a high level and they really like you. And you gave them all the information, and they or he or she or they did not tell you they were working with another agent, but they submitted an offer with you. Okay, and that happens more so often, where they'll be utilizing you as the agent representing them in the offer. Okay, and it may be your listing, or it may not be your listing. You might be just hosting an open house, but you connect with someone at a high level. They like you, they want to do business with you, and they're willing and ready to submit an offer because there was something that resonated with you and them that ultimately they felt comfortable making an offer. I hope that kind of makes sense. So obviously you have to distinguish. One is the connection to the transaction, why the buyer is choosing that specific agent, okay? Because it can be the other way around, folks, okay? If you don't have a buyer representation agreement in place, you're basically exposing yourself. You really don't have really a control. Remember what I said earlier, it's like a marriage, okay? In the beginning, it's exciting. They're thrilled, they're excited to make their first purchase. But there's a lot of vultures out there. Okay, and when I say vultures, I mean other agents out there that are ready to take that kill. Okay, and take your clients. This is why you have to properly educate your client and really sit down with them and explain the pros and cons and really nail and anchor those conversations and understand that there's like the lion that's teaching his cub, the lives of, living and hunting, right? Well, that's the same thing as your buyers. You got to understand that there's vultures that are ready, willing, and able to take your clients. But if you don't properly educate your clients, then they won't cheat on you. They won't leave you. Okay. And that's very frustrating and sometimes very emotional. And I want to make sure that that doesn't happen to you. This is why you have to have a serious sit down conversation and explain what the initial process. That way, one, they feel comfortable, they like you, and they trust you. And they'll be committed throughout the entire process and close with you, and you'll end up getting paid a commission. The other elements to the categories of factor is the broker conduct. Okay, was the other agent or broker being misleading? Well, Mr. and Mrs. Buyer, if you choose me, I'll make sure to get your offer accepted. But only if you work with me, I'll make sure to get the seller to accept your offer. I have the insight, I have the intel. I can provide you with information, but only if you use me. Now, your buyers are thinking, okay, if this listing agent has so much influence, why wouldn't they use that if they fall in love with the property, right? It's the lure, right? And that's when sometimes buyers will second guess themselves and think, well, you know what, we really want this offer. We've been working with Simon for the last 90 days. He has not been able to find us anything we like. We submitted offers, but he has not been able to get our offer accepted. Those so many variables that can happen, team. So I want you to understand your position. And more so that there's vultures out there that the minute they see a potential buyer at any cost, they're going to try to grab the buyer. If they're pre-qualified, they have the funds and they're solid. Okay, so you got to understand the position and what the broker conduct is, and it goes into details here. The conduct of the second broker could be the closing broker have prevented to the problem. Did the closing broker engage in an inappropriate conduct that contribute to the breakup? As I mentioned, there's agents out there that do not play by the right rules. Okay, there's agents out there that are not in the same field. They shouldn't even be real estate agents. I'm just being truthful. Okay, and at any given time, all they see is money, and they're going to do whatever it takes, even though they may be out of content on this and maybe doing something they shouldn't be doing, which could lead to an ethics, an ethics complaint. If they're misleading or luring them to work with that particular agent. So, shame on those agents that do so. But at the same time, I want you to protect yourself as well, because you cannot be with your clients 24/7 and see exactly what they're doing. You might be doing everything correct, and it's just that one open house, that one on their app, and they go and drive by when they're hosting an open house. And that's when it's the exposed. It's like the trap, right? The cheese on the trap, and the mouse sees it and smells it, but doesn't know what the end result, and they'll trap that buyer. Okay, and there's very, very good agents out there that understand, scripts, objection handlers, and ultimately try to lure them to work with you. This is why this comes into play: procuring costs. Okay, because if you arm yourself, you shield yourself, then most likely you're going to be able to win a compensation. Good riddance. If the buyers are not going to be loyal to you, okay, but you know what? If it was because of that agent, we may be entitled to a commission. Let them deal with the responsibility, but let's still collect a commission. Make sense? So I just want you to understand the elements of the connection of the transaction, the choice from the buyer on why they decided to go in a different direction, the broker's conduct, what they're doing or saying to alter their position to work with someone else, and then the contractual and miscellaneous use that are relevant to the ultimate decision. Okay, and that's most of the additional paperwork that involves. Do you have a copy of the pre-qualifying letter? Do you have copies of proof of funds that the buyer was at one point in time committed? Maybe you have a copy of their license. The more ammunition that you have, the better position to alter and diffuse and win in an arbitration procuring cost case. Any questions so far? Okay, so here's some of the examples. Who first introduced the buyer to the property? Okay, how much time elapsed between the first broker showing the property and the second broker writing the offer? Who ultimately wrote the offer that got the accepted and performed services during the escrow? Why did the buyer choose to leave the first broker in the first place? Was there a buyer representation agreement in place, the BRE, folks? Okay, so here's some of the examples of timelines that can alter our position. Who introduced the property to the buyer? Was it you or was it someone else? Because if you send someone out, you send your buyer to go see a property, but you're not physically there, how do you protect yourself? Because there's, again, elements of things that must happen in order for the arbitrator to decide who is entitled to a commission. And then ultimately, how much of a time gap? Because if you lost that connection with the buyer, you were excited, you got a buyer representation agreement, but that agreement was only for 90 days and that lapses or expires. And on the fourth month, you don't realize that the buyer's representation agreement has expired, and now they go into a different direction. And you're saying, well, wait a minute, I'm entitled to a commission. Well, here's the avenue that I have to disagree. Because if I'm the agent now representing the buyer, I'm going to ask those questions, and I'm going to ask real hard questions to the buyers. I'm going to ask, are you working with the buyer's agent? Yes. Okay. Did you sign a buyer representation agreement? No. Okay. And the reason I'm setting myself up for that, because I need to know exactly, because can a buyer terminate an agency relationship with an agent? The answer is yes. Yes. Okay. The buyer and the seller can terminate each other's agency agreement. Okay. Anyone, the buyer can say, Simon, you know what? Thank you for working with us. Unfortunately, we tried for 90 days, and I just don't see any results. I would like to sever that relationship and terminate our agency agreement. No problem. Okay, there's a form on Zip that allows you to terminate that relationship. You, as the agent, also have that right to terminate the agreement with the buyer. If you're just not seeing eye to eye, there's no meeting of the minds, the buyers are going in a different direction, they're just not being realistic. I don't want to work with unrealistic buyers. I'm going to cancel on them because they're not being realistic, okay? They want to submit an offer for $500,000 on a $1.5 million home, okay? They want to live in a high desirable area, but they're not willing to pay for it. I'm not going to waste time, effort, and energy. I'm just being truthful. Then let someone else deal with it. Maybe someone else has another avenue in how they can approach it to make them come up, or maybe they just don't qualify and are maxed out at 500. But that's your job to understand those elements and how to have those conversations and ultimately explain the initial reason why homeownership is the best investment you can. Because I know that if I'm working with the buyer and the buyers are not realistic, I'm going to anchor that conversation immediately and have that conversation. Look, This is not this is not only your, this will not be your only home you're gonna buy. In 2 to 3 years, you'll build some equity, you'll pay down some of the mortgage, you'll be able to, sell this property, rent this property, and who knows, you might have a bigger, better job, more income that in 2 to 3 years, you might be able to buy in a more desirable area, move to the area you want to move into, or sell the property, pull out the equity and put a stronger down payment. There's many variables that can happen. So I usually have the conversation with the buyer and say, look, this is not your final home. Okay, this is your beginning. This is your first home. There's many memories that you'll have, but this is only a stepping stone. I'm still waiting for my final destination. Okay, where I know where I want to live. Okay, and I'm almost there, but not quite there yet. But I know where I want to finalize when I'm ready to retire, and that may still change. Where I might not want to. Maybe I'll go to Hawaii and live there. But you get my point. If you're not asking the right questions and really pulling that information from the buyer, you'll never know. And this is why there's separation. This is why there's no meeting of the minds and eye to eye with the buyer and the buyer's agent. But if you anchor those conversations immediately, you'll understand one another and you'll have a successful closing, and you won't have to deal with, excuse me, with procuring cost claims, because they ultimately go with another agent. Okay. Any questions regarding the examples here? Okay, let's continue.
Simon,
Yes.
it's Christine. I just have a question about the buyer's agreements. Would you also put that in your calendar to do a class on that?
Absolutely.
I've had so much, like, we're just reading it, like kickback from it, that I was doing, especially during COVID when we had the avids, including an AD,
Yeah.
because then that kind of cements me that I'm there, right? I'm representing them. So I kind of was using that, but I haven't been bitten yet, but I know that there's issues with it and, from other agents. So, just having I have a verbal conversation, which you're right, buyers are liars. It may not mean anything, but I have a thing about, I'm committing to you, so you're committing to me type of thing. But I would like to be more comfortable, other than using the AD, using the buyer's representative agreement. It's just that it's so wordy and legalese that I think, my personal opinion is if somebody gave it to me as a new buyer, I might be intimidated by it. So I'd like to have some kind of class or something about that, if you could.
Absolutely, Christine. Yes, I got it written down here. I will have a lecture on buyer representation agreements. Now, and just to kind of side note on that too, is I've seen where agents, they feel the same way, is like, this is really overwhelming. It's a lot of jargon, legal stuff, and the buyers are sometimes very adamant about signing these buyer representation agreements. What other resources do we have? Well, I've seen where agents will have like loyalty agreements. And these loyalty agreements basically, say, look, I'm loyal to you, as long as you're willing to get pre-qualified, you'll work with me. But those agreements, I'm going to tell you, will not hold water if they decide to cheat on you. They decide to go in a different direction. Okay. This is why the California buyer representation agreement are really geared to protect you and also the agent as well. I mean, the buyer as well, because it really concise and clearly states the do's and don'ts, and it also has a beginning and an expiration date. Now, let me ask you this question, okay? And I understand what you're saying about buyers, but let's transition and go into a conversation of a seller. Would you list a property with no guarantee that you have an exclusivity or an exclusive right to list their property? And you go through all the motions, hire professional photography, drone, virtual tours, and spend all this marketing expenses without an exclusive, and now the seller decides to go in a different direction, or better yet, they get an offer from someone else, and because you don't have an exclusive listing agreement, they're not entitled to pay you a commission. So why wouldn't you do that with the buyers as well? I just need a commitment, and I know how to approach this buyer agreement. As a matter of fact, I will be helping one of our agents this Thursday, coming, in 2 days. We're meeting here at the office at 6 o'clock. She's a seasoned agent, but hasn't really done much business. But she goes, Simon, if you can help me convert this buyer to have them, commit to something, I would really appreciate it. I said, no problem. I'll step in there and I'll navigate and help you get that buyer representation agreement. Now it's the approach. It's how you approach the agreement. I'm not just going to throw, you must sign this buyer representation agreement, because any buyer is going to be very defensive about it and probably will not sign on the agreement. And I've seen most agents that will never have a buyer. Oh, I don't need to sign a buyer representation agreement. And that's good and dandy. I've done it, and I'll be the first to tell you, I've done a lot of transactions without a BRE. Okay. It's just because I have a great dialogue, great conversation, and I have that relationship. Okay. But then I kick myself in the rear for not having a buyer representation agreement, because I've lost buyers, and I've lost buyers who I've helped them sell their home and now transition and buy a property. That happened to me maybe 5 years ago. He was a doctor. I helped him sell his little baby mansion in Walnut. At the time, I think it was about 2.2 million. Sold the property. And I never did sign a buyer representation agreement. And they were looking and buying in Newport Beach for a $2.83 million property. I thought, well, I was successful in closing the deal on their sale of their property, but gosh, I didn't think they were going to go in a different direction. And I was not familiar really with the market in Newport Beach. And the agents out there are very, very cutthroat as well. So apparently they ended up, having a conversation with an agent, and that agent, unfortunately, induced and said, look, if you want this property, then you must work with me. And because I didn't have a buyer representation agreement in place, I did not want to raise, because I got a pretty decent commission out of it. So I didn't fight it, but I could have probably challenged that and said, look, we have a commitment, we have a representation agreement, and it was an after the fact. Now, the good thing about the seller who transitioned into a buyer, he asked, and he says, look, Simon, I just want to make sure, do we have something in writing that says that we're committed to you? Because if that's the case, then we're committed. But if there's no case, then I think I want to go in a different direction. So they were very transparent, and who's gonna say no to that? But it was my mistake, and I should have had a buyer representation agreement. And that's just a proven fact that even if you represent them on the sale of their home, you must and you should have a buyer representation agreement in place. But to answer your question, Christine, I will definitely in the future have a class on BREs, because there's 3 different buyer representation agreements. Okay. All right, let's continue. Tips to avoid on a procuring cost dispute. Always ask a prospecting buyer whether he or she is working with another agent. That is common sense, folks. Common sense. Okay, that's the first thing I'm going to ask if I'm hosting an open house. Mr. and Mrs. Buyer, are you working with another agent? Okay. And even if they say yes, right? Yes, I am. Wonderful. Are you happy with the agent? Because again, what are buyers? Buyers are liars. Maybe they'll open up to us and let us know, you know what, in all honesty, no. I just said that because I didn't want to be trapped or, obligated to, have a conversation, because we're just basically looking. But at least I'm open to it, and there's nothing unethical about that. Fantastic. Are you happy? Because what if they're not happy? What if the buyer agent has been MIA, okay, been void? They haven't been in communication. There hasn't been any dialogue. The buyer's agent might have lost the interest and say, gosh, these buyers are just difficult. It only takes that one agent that makes that buyer happy, and they are willing to work with them. So this is the reason you want to ask these questions, especially if you are working and hosting an open house. Okay, if yes, ask whether the buyer has a signed exclusive representation agreement. Yeah, what part of the follow-up question is, do you have a buyer representation agreement? No, we don't. Okay, wonderful, wonderful. Now, ultimately it's your discretion and your choice in how you navigate that. Because I've seen it firsthand, I get a lot of the blunt of the complaints that come in, and I know I'm cutting it close to our 3 o'clock, and I apologize. If you have to, log off, by all means, please do so. You won't hurt my feelings. But if you can hang in there for another 5 to 10 more minutes, I promise you we're almost done with this, okay? So in essence, the importance of asking the right questions will give you the answers to know how much information you must. Because if they do say, yes, I'm working with an agent, yes, I have a buyer representation agreement, yes, I'm happy with my agent, okay, well then, please make sure then I can have that conversation. Then any and all questions, excuse me, can be, answered by your agent. Have your agent reach out to myself or the agent, because we're not representing you, and I don't want to cross that line and say something. Just have your buyer's agent reach out to me, and I'll be more than happy to provide, because that's really the direction you must go with this, right? Agent to agent conversation. You're not going to be in a transaction, right, wherever you represent the buyer or the seller, and go and call the seller when you don't represent the seller, right? Hey, Mr. Seller, by the way, this is Simon with Keller Williams. Just wanted to let you know your agent let me reach out to you regarding concessions. That's just not the way it works, right? We go through and we speak with the agent. That's why we have licensed agents involved in these transactions. If you discover your client has been working with another broker on the same transaction, ask why the client left the first broker, and if appropriate, make immediate contact with the broker and try to resolve the issue, okay? Don't risk working through a difficult escrow, closing the transaction and not getting paid. If you know immediately, team, if you know immediately that your clients are cheating, immediately bring it to your broker's attention and take the necessary action. Don't wait, don't prolong this and then wait until it closes, because by that time, I can tell you it's going to be very, very difficult, because remember, it's like the scale, the weight of the law, right? Whoever has the most compelling information and documentation and process will ultimately win. It doesn't matter if you're related with the buyer, but if this other agent has the buyer representation agreement, an executed purchase agreement, has open escrow, closed escrow, and bought the property, they're going to see it in a different light. They're going to say, yeah, I understand that's your brother or your sister, but this other agent was the compelling factor, and therefore you're not entitled to any commission. Okay. Use buyer representation agreements with or without a compensation. Remember, as I said, Christine, there is 3 forms of the BRE, 3 forms. Memorize the relationship and properly discover of the other broker relationship. If a buyer's commission is included, it will also create an incentive for the buyer to come to you and terminate the contract prior to going through another brokerage. Okay. Remember, if you do end up having a buyer representation agreement in place and they end up going with another one, you might still be able to save that transaction and may navigate or realign the buyer to coming back and use you, just because that contract is very defined. And it says that if they end up going in a different direction, then the buyer is responsible to pay you the commission. Not the agent, the buyer, okay? Now, the elements of the contract are very defined and very crystal clear, folks, that it says that, the buyer is responsible to paying you a commission if they go in a different direction. And if it's within the contract, right? This is why they have a beginning and an expiration date. And if it falls within those parameters, then guess what? You can go after and go into a procuring cost claim and have the buyer or the other agent. And maybe the agent doesn't want to be involved with them. They said, look, you know what? I don't want this to go any further. It's going to delay the process. Either you take the client back or we close and I'll just pay you a referral. And that's the end goal, right? That is the end goal, that at least the agent understand is practical and using common sense and is willing to pay. And I've seen that more often than never, that an agent, steps up and says, look, I'll make it as easy as possible. At close, we'll make sure to pay your referral, okay? And whatever that referral, 20, 25, or 30%, okay? Accommodate the clients to open house. I have to say, the best reinsurance is obviously go with your clients to every showing, okay? Especially high-end stuff, multi-million-dollar properties. These agents are very savvy, very experienced. Even though it may take, half of your day, all day to show 4 or 5 properties, you want to be there, okay? Because now the presence, and you have control. Now if your clients are talking to the listing agent or whoever's hosting that open house. Okay, if you cannot give a client your card instructions, instruct them to tell the other agents they're already working with you and present them your card. So yeah, I've done that in the past too, and I always educate the agents. If you cannot for any reason be involved with showing the property, give them a stack of your business card and say, look, agents are going to be agents. They're going to try to seduce you into working with them. Just here's the silent card. Just give them the card. You are working with an agent. Here's my agent. If they have any questions, they can call me direct. And for the most part, any agent that gives instructions to their clients to give the business card usually stops in their tracks, and the agent will probably not ask any more questions. One, someone is giving me a business card, they're obviously working with someone. But the question is, is the buyer still obligated because the agent that's hosting the open house lured or to submit an offer with that? Can we go after for procuring costs? And the answer is yeah. As long as you have those elements, right? The buyer representation agreement, you gave them a stack, and all that is going to be part of the complaint that you're going to file, the summary that you're going to file. That way, the scale weight of information that you have is more compelling, and they can see that from your side. Stay close in contact with your clients and be responsive during the transaction. If you're conducting an open house, keep a registry of all prospective buyers, including a note of whether there was a broker with the buyer. Keep a record that the agent sitting on the open house asked the buyer if they were working with an agent. For listings where the property is being shown by brokers when you are not present, leave a sign-in sheet with buyer's name and broker's name, similar to those at a new home development, okay? And include dates and times in the registry. This creates a record of who was shown the property and which brokerage. Again, the only way how you can protect yourself is documentation, okay? Documentation is truly, truly, truly the best way to protect yourself, okay? Because again, at the end of the day, folks, I want to make sure you get paid, okay? I don't want you to go into motions and get involved and then realize that the buyer went in and cheated on you and went with another agent, okay? So keeping proper documentation is very crucial. Additional resources, the procuring cost guidelines. You can go to the California Association of Realtors, type in procuring costs, and it'll pop up this guideline, quick cheat sheet, okay? And legal live webinars, procuring costs. There was one recorded. And again, just go into the additional resources on California Association of Realtors, and most of the information is straight out of the California Association of Realtors. All right, so with that being said, that concludes our training. Any questions?
Simon, I just posted something in the chat, but for whatever reason, if I can't make it, I always contact the listing agent and have documentation like a text saying, hey, I'm registering my client, blah, blah, blah. They have my card, so then it shows that that's what I've done. So if I ever had an issue,
Okay.
I did not.
Anything and everything, I would definitely call the listing agent if you do have an opportunity that let me rephrase that. If you don't have the opportunity to go with your clients on showings and you navigate and there's maybe a couple open houses, I'll call the listing agent, Mr. and Mrs. Agent, this is Simon with Keller Williams. By the way, I know you're hosting an open house from 12 to 3. I'm having Mr. and Mrs. Ramirez or Hernandez or Smith showing the property. So if they have any question, are you the point of contact or are you going to have someone else hosting the open house? Oh, it's going to be so-and-so. So then at least I have that information. Okay. Bye, Christine. Thank you. Okay. So again, you know, understanding the elements of a procuring cost. And again, let me go ahead and put in my email address if you want me to send you the procurement cost manual, Simon Cazares at kw.com. All right, team. Well, that concludes. Thank you. Appreciate you. I apologize for going 9 minutes past 3 o'clock, but I hope that this was of some value to you. Anything you have, please feel free to reach out to me, send me an email, and I'll be more than happy to answer your question. Okay. Thanks again. Have a wonderful afternoon, and I'll see you on our next call.
Thank you, Simon.
Thank you. Yeah, you're welcome. Thank you.